Hi, my name is Gennady, and I'm an attorney with the Law Office of Yuri Moshes. Today, I'm going to discuss what constitutes an adverse employment action in the context of FMLA retaliation claims. Life has a bad habit of interrupting your perfect plans at the wrong times. For this reason, the federal government allows all qualified employees to take unpaid leave under the Family and Medical Leave Act, or more commonly known as the FMLA. The FMLA also makes it illegal to retaliate against an employee for taking leave pursuant to the FMLA. Under federal law, an employer commits unlawful FMLA retaliation when it takes an adverse employment action against an employee in retaliation for taking FMLA leave. Now, I'm going to explain an adverse action in the FMLA retaliation context and explain how you can bring an FMLA retaliation claim if you have experienced such retaliation. Now, what is an adverse employment action? The employment laws of the United States generally protect employees from adverse employment actions taken in retaliation for reporting violations of the law. The same principle applies in the context of FMLA retaliation. The phrase adverse employment action seems vague, but it does have a specific definition. For purposes of an FMLA retaliation claim, the legal definition of an adverse employment action is any action by the employer that is likely to deter in the plaintiff's position from exercising his or her legal rights. Now, an adverse employment action is more disruptive than a mere inconvenience or an alteration of job responsibilities. Some examples of adverse employment actions include termination of employment, a demotion evidenced by a decrease in wage or salary, less distinguished title, a material loss of benefits, significantly diminished material responsibilities, or other indices unique to a particular situation. Only in limited circumstances does a single acute incident of abuse qualify as an adverse employment action, such as when the incident constitutes an intolerable alteration of the plaintiff's working conditions so as to substantially interfere with or impair his or her ability to do his or her job. What are some actions which are considered adverse employment actions? Actions such as firing and demoting are adverse employment actions. In addition, other actions that are not job determinative employment actions can also be considered adverse employment actions. For example, lateral transfers, unfavorable references, and the imposition of more burdensome work schedules may also be considered adverse employment actions. Now, this is because these actions are severe enough that they may deter an employee from exercising his or her rights under the FMLA. It is impossible to compile a complete list of adverse employment actions because there are any number of ways that an employer can try to punish its employees. Over the years, many lawsuits have helped to define the boundaries of the definition of adverse employment action. As attorneys, we see many forms of adverse employment actions. You can find the most famous lawsuit examples in our blog. The following are some examples from there. Placement of an employee on administrative leave, cuts in monthly base salary, failure to receive promotions, negative job references, transfer of job duties and undeserved performance ratings, failure to hire, extended disciplinary suspension. Other examples also include denial of a transfer, layoff or termination, deprivation of the ability to take a promotional exam, loss of pay and opportunities for investigative or other job experiences, low ratings on job performance reviews or evaluations, decreased job responsibilities. Now, what are some signs of FMLA retaliation to look out for? As explained in the previous section, there are many different possible ways that an employer could illegally retaliate against you within the employment context. It is impossible to cover every situation involving adverse employment actions. If you have a situation which makes you think that you have been discriminated, you can call us. We provide free consultations. Now, retaliation can take the form of staffing changes after you return from FMLA leave. The FMLA requires an employer to allow you to continue working in either the same position you left or in a substantially similar position. The position can legally be a different position, and it can even be a different department. There is no guarantee your exact position will be open in your same spot, in your same department. However, you may have a claim for retaliation if you return to work and have found that you have been demoted, are given less pay in your new position, lose seniority and must start at the bottom of the ladder again, are no longer eligible for a promotion that you are qualified for, are being kept off of prestigious accounts or additional responsibilities because of your leave, have been diverted to mommy track, or are now required to do things in your new position that you were not previously required to do, such as lift heavy objects or work in a position where you are on your feet all day. How does the FMLA protect you? The FMLA provides qualifying employees with up to 12 weeks of unpaid job protected leave each year. All 12 weeks do not need to be used at the same time, and employees can take FMLA leave on multiple different occasions as long as they do not exceed a total of 12 weeks of leave over the course of the year. Employees can use leave only as needed, often referred to as intermittent leave, and must return to work as soon as they are able to. If an employee takes more leave than allowed under the law, the employee can legally be fired. It also requires that qualifying employees' group health benefits be maintained during the leave period. The FMLA is intended to assist employees in balancing their work and personal life responsibilities by allowing them to take short periods of unpaid leave for family and medical reasons. The law was also drafted narrowly to accommodate an employer's business interest to avoid overburdening an employer in the marketplace. The FMLA applies to various employers, including public agencies, public and private primary and secondary schools, and any company that employs 50 or more employees. Those employers must provide each eligible employee with up to 12 weeks of unpaid leave each year for any of the following reasons: medical leave for any employee's serious health condition that renders them unable to work, the birth and care of a newborn child, or the adoption or foster care of a child, or medical emergencies and the care for an immediate family member, such as a spouse, child, or parent that have a serious health condition. An employee is eligible for FMLA leave if he or she has worked for the employer for at least 12 months and has worked at least 1,250 hours over the past 12 months. Things to do before you take FMLA leave. There are many reasons that employees may take FMLA leave. Many of these reasons will be due to sudden medical emergencies, whereas others may be planned events such as a pre-scheduled surgery. If you have the time to plan a medical leave, as in the case of a scheduled surgery, pregnancy, adoption, or some other known leave date, you will want to discuss your taken leave with your employer's HR department. There are several reasons for this. First, placing HR on notice will make it much more likely that your employer can plan around your absence, which makes retaliation less likely. Second, discussing your plans with HR will allow your employer to voice any concerns they have with your leave time so that you and your employer can work out a deal that works for everyone. Some of the things you should discuss with HR about taking FMLA leave should be whether your company requires you to use accrued paid time off to cover some or all of your FMLA leave, whether there is any paperwork that must be filled out. Make sure you complete all paperwork before taking your leave. You don't want the concern of unfinished paperwork hanging over your head. You should also mention to HR whether your leave will be full-time or intermittent, whether a medical certification is required, and find out how benefits other than health insurance will be dealt with during your leave. If your leave is unexpected, such as in the case of an auto accident or family medical emergency, you are expected to contact your employer and complete any paperwork they need within a reasonable time of taking leave. Under the FMLA, a reasonable time is generally considered to be a few business days, but the timing will depend largely on the circumstances that required you to take leave in the first place. In general, you should act promptly to notify your employer of the need for leave in conformance with their call-out or leave request procedures if possible. If you simply cannot comply with the employer's procedures, take the steps necessary to get in touch with the employer as soon as possible, even if you need to ask a third party, such as a spouse or a parent, to assist you by calling your employer on your behalf. Now, what should you expect when you return from FMLA leave? As stated previously, the FMLA guarantees that when you return from leave, you will either get your same job back or some equivalent job. However, that does not always happen as expected. This is probably the most shocking part for most employees. Employees expect to return back to the exact same job at the same desk with the same view, but the law does not ensure that. The law only says you must be restored to an equivalent job. The department you work in and the office space you have, but your employer must provide the same pay, same benefits, and employment conditions. Additionally, you cannot be stripped of any benefits that you earned or were entitled to before you took leave, such as seniority benefits or a pension plan. What do you do if you have experienced FMLA retaliation? If you have experienced any type of job displacement or demotion after returning from medical leave, you may be a victim of FMLA retaliation. The first thing you need to do is document the details of the actions you believe constitute adverse employment actions and those involved with them. Then, you should contact the wrongful termination lawyer. While few employees expect the workplace to look exactly the same as it did before their medical leave, many employees return to work to find their hours cut, their wages decreased, or their positions changed. These types of serious adverse employment actions could serve as the basis of a lawsuit. If you have experienced unlawful retaliation, you should contact an attorney to discuss your possible legal claims. Now for a disclaimer. The information in this video should not be considered legal advice. Every case is different. If you have questions, you should call an experienced labor and employment attorney that deal with FMLA retaliation issues. Additionally, Subscribe for our video channel and newsletter. Every week, we produce interesting content covering different issues of labor and employment law. If you have any questions or topics which you would like us to cover, please leave a comment in the section below the video. Thank you.